Ladies and gentlemen, good afternoon. Welcome to this roundtable organized by ELNet, the Open Leadership Network, and the FSD, Forum of Strategic Dialogue. Today, we have the opportunity to discuss with European, American, and Israeli officials, policymakers, experts, and journalists the stakes and consequences of the ICC controversial decision to open an investigation into alleged war crimes committed by Israel in the state of Palestine. Although Palestine may not be a state in the meaning in the international law rule, but is considered as a state in the meaning of Article 12.2 of the Statute of Rome. This question involved consideration of the most fundamental principles of public international law, including the legal criteria for statehood. Judge Peter Kovacs criticized the majority of the PTC and denounced what he called, and I quote, acrobatic with provision of the statutes that cannot mask legal reality, unquote. 7 ICC member states, the Czech Republic, Austria, Australia, Hungary, Germany, Brazil, and Uganda, and numerous experts strongly objected to the prosecutor's claim of jurisdiction. It is quite ironic, not to say tragic, that the state of Israel, which was involved in the vision of creating an independent international criminal court after the atrocity committed against Jews during the Second World War and the Shoah, has now become the target of that very international criminal court and find itself being accused by a court influenced by the Palestinian strategy to delegitimize Israel in international organization. In doing so, the court could prejudice its juridical credibility. By using non-binding resolutions adopted by an automatic majority of countries hostile to Israel, the ICC creates artificial and illegitimate law. We should be preoccupied by the fact that the Palestinian campaign of demonization and delegitimation of Israel feeds the double standard against the Jewish state in international organization and has also, and we see that today, consequences on the ICC. But it will be about that we will discuss today. This roundtable will be divided into 2 parts. First, we will focus on the legal aspect of this decision. Then we will discuss the geopolitical implication. To start the first part, I am glad to introduce our first 2 guests, Professor Irwin Cotler and Justice Elyakim Rubinstein. Irwin Cotler is the founder and chair of the Raoul Wallenberg Center for Human Rights, an emeritus professor of law at McGill University, former Minister of Justice and Attorney General of Canada, and an international human rights lawyer. Justice Elyakim Rubinstein, that you will hear just after Professor Irwin Cotler, was appointed Justice of the Supreme Court in 2004. In 2015, he was appointed as Deputy President of the Supreme Court, a position he held until 2017. Prior to his role as a Supreme Court Justice, he served as the Attorney General of Israel, where he participated in negotiations with Syria in the Camp David Summit and as the head of the Israeli delegation to numerous conferences about intolerance and anti-Semitism. Professor Irwin Cotler, you have the floor for the next 7 minutes. Thank you very much. Please.
Thank you, Arie, for those kind words of introduction. May I begin by commending ELNet and the FSD for organizing this timely and significant roundtable. And I'm delighted to be joining Judge Elyakim Rubinstein, whom I regard as one of the best jurists that Israel has ever produced and who brings a unique repository of experience and expertise to this topic. Regarding our particular subject matter, I come to this as a longtime supporter and one who has been engaged with the ICC from its inception. Indeed, as a member of Parliament, I initiated the first ever legislation to domesticate the Rome Statute into Canadian law. As Minister of Justice, initiated the first ever prosecution under the principle universal jurisdiction authorized by that statute, and in 2002 chaired the first ever parliamentary assembly for an international criminal court and have been involved with them to date. I mention all this because it relates to my having been appointed as one of three legal experts, as we were called, to look into, and this was in 2017, to look into whether there are reasonable grounds to believe that crimes against humanity are being committed in Venezuela. Following an exhaustive inquiry, we determined in May 2018 that 7 major crimes against humanity were being committed in Venezuela. Some 4 months thereafter, Canada led 7 state parties, including Germany and France and Latin American countries, in the first ever collective referral to the International Criminal Court of a state party, namely Venezuela. Regrettably, notwithstanding this, and even though our report was further confirmed and elaborated upon by investigations undertaken by the UN Commission on Human Rights, and more recently in December 2020, when the first ever special advisor on the organization to the Organization of American States on the Responsibility to Protect, Jared Genzer, produced a landmark report which not only elaborated on the crimes against humanity being committed by Venezuela, including over 15,000 extrajudicial executions and the like, but condemned the refusal of the special prosecutor to open an investigation with regard to Venezuela, saying that this was in fact incentivizing impunity in Venezuela by not opening an investigation. I mention all this by way of backdrop because the special prosecutor did determine to open an investigation in a matter of the situation in Palestine, even though, number one, Israel was and is not a state party to the ICC and has not consented to its jurisdiction. Even though, as you mentioned, Mr. Chair, it was one of the founding states in terms of the inspiration for such an international tribunal. Even though the Palestinian Authority was not a state, and therefore, since it was not a state, much as some of us have advocated that it should become a state when it comports with the qualifications for statehood as set forth in the Montevideo Convention and the like, but because it is not yet a state, it cannot thereby confer jurisdiction on the ICC. And so what in fact, what the special prosecutor was doing as the majority decision of the pre-trial chamber was to turn principle and precedent on its head, to confer jurisdiction on the Palestinian Authority as if it were a state, whereas the Palestinian Authority had to have been a state in order to confer jurisdiction on the ICC. And it does not end there, because the decision of the pretrial chamber and that of the special prosecutor to open an investigation is in standing breach of the Oslo Accords, which in fact preclude the Palestinian Authority from exercising criminal jurisdiction over Israeli nationals, and whereby under the Oslo Accords, the Palestinian Authority has no jurisdiction or authority in Area C. A whole set of considerations as to why the decision by the special prosecutor in the pretrial chamber is in standing breach of the Oslo Accords. And I note that Dennis Ross is speaking later, and he has written brilliantly on the politicized nature of this prosecution in the matter of its breach of the Oslo Accords. But it doesn't end there. There is also, and with this I will bring to move to a close, a reasonable apprehension of bias in the matter of the conduct of the special prosecutor, who relied on prejudicial UN General Assembly resolutions and prejudicial resolutions adopted by the UN Human Rights Council under Article 7 of the UN Council on Human Rights, which singles out Israel for selective opprobrium and indictment, relied on prejudicial resolutions, as I say, to turn principle and precedent on its head and confer authority on the Palestinian Authority as if it had jurisdiction as a state to in turn confer jurisdiction on the ICC, which was not the case. Finally, I might mention that in one of my visits to the ICC in the matter of Venezuela, I encountered an astonishing decision that was made by the pretrial chamber to invite testimony from alleged victims of Israeli war crimes, even before the ICC had even determined, even before the special prosecutor had opened an investigation, and even before the pre-trial chamber even made any determination of jurisdiction, inviting testimony from prospective victims. So here too, yet another example of others that I could give of why there is a reasonable apprehension of bias. And I will conclude only by making reference to, in September 2020, the oversight body of the ICC reported on the functions of and conduct of the ICC, and said that the conduct of the ICC was in fact dysfunctional, that the atmosphere was toxic, that there was bullying, sexual harassment, and the like. And here too, it called upon the court to effectively revisit its priorities and purposes so that it would be acting with regard to the pursuit of international justice, which was its initial mandate. And therefore, if one looks even consequent upon the opening of an investigation with regard to the three conditions of admissibility, which have to be in fact determined, namely that the investigation will comport with, and the prosecution, the conditions of admissibility, read the gravity of the offense, read the principle of complementarity, read the interest of justice in each and all of those three, it does not meet the threshold tests. And so I will conclude by saying that the opening of an investigation, let alone the determination by the majority opinion and the conduct by the special prosecutor throughout in this regard, is in standing breach of the initial purposes of the court itself to be a court of last resort in the pursuit of international justice. It is prejudicial, therefore, not only to the interests of the state of Israel, let alone also to any peaceful negotiation between Israel and the Palestinian Authority, in its standing breach of the Oslo Accords, but it is undermining the very principle and purposes of the pursuit of justice that is the essential mandate of the ICC. And that is that which should concern all of us, who we should see ourselves singly and collectively as being trustees for the pursuit of justice. And if we have the interest of the ICC at heart, we have to ensure that any prospective investigation comports with all the principles of justice, which have hitherto, as I said, been breached in every ascent. Thank you.
Thank you very much, Professor Irwin Cotler. Now I'm very pleased to give the floor to Justice Elyakim Rubinstein. Mr. Rubinstein, for the next 7 minutes, you have the floor.
Thank you very much, Dr. Bensemhoun. I'm proud to join my friend and esteemed, very esteemed human rights lawyer, Professor Cotler here. And thank you very much for having me this afternoon. You know, everybody knows the general history of the Jewish people, which includes persecution throughout generations and the views of human rights. The climax was in the Holocaust, and this is not paranoia, this is a historic fact. And we just marked last week the Memorial Day of the Holocaust. I come from a family that perished in the Holocaust. My grandparents and the whole family were shot into a mass grave in Belarus in August 1942. And it's then no wonder that Jewish legal scholars were the pioneers of modern international law of human rights. René Cassin was the one of the founding fathers, if not the founding father, of the Universal Declaration of Human Rights in '48. Raphael Lemkin initiated the Genocide Treaty and, in fact, coined this term. Hersch Lauterpacht, Jacob Robinson were on the cradle of modern international human rights law. Personally, as Attorney General of Israel, I was the chair of our delegation to the Rome Conference back in 1998. And when the ICC was established, we supported the noble idea of the of the code, but we warned from and against apprehensions of politicization of that code, which is against the DNA of any code. I'll quote from my presentation in 98. The court must retain a clear focus on the most heinous of international crimes and the non-availability of national criminal justice. It must be complementary to national criminal justice system in cases where trial procedures might not be available or effective. Where effective national procedures are available, the establishment of alternative jurisdiction was not only unnecessary, but might even diminish the effectiveness of national procedures. The second principle was the need to exercise the utmost caution in trying to ensure the objectivity and impartiality of the court, not only to ensure its effectiveness, but also to encourage states to accept the new body. Inevitably, the fact that complaints were to be filed by states created the possibility that the investigative procedure might be abused for political ends. This is from 1998, and because of our fears and apprehensions then, which became clearer throughout the conference, we did not, at the end of the day, join the treaty. The fears, the apprehensions that I mentioned were exemplified by what we have now. And I must say, many of us felt suffocated by the decision of the prosecutor and the pre-trial chamber. In fact, when I read it, I felt that the proper approach was taken by Dr. Kovacs, the Hungarian minority judge, but he was in the minority. Moreover, my friend Professor Cotler mentioned that the court basically wastes its time on the cases that are brought before the court on the Palestinian issue, and I'll say in a minute why, and does not deal with heinous crimes that do not have national procedures and national tribunals. Professor Cotler spoke about Venezuela, but there are other cases. Syria, our next door neighbor, as I mentioned in an article with Brendan Silver from the Raoul Wallenberg Center in Canada, Syria has committed crimes against its own population in a massive way, of hundreds of thousands of people maimed, killed. Where is the investigation? Where is the court? Israel makes, and whoever knows the history of the Israeli-Palestinian conflict knows that the complaints filed with the court, regardless of jurisdiction, are for political ends, not for real criminal investigations. 2 points are made. Professor Cotler spoke about jurisdiction, and and we have our position. I will not dwell on it because of the time constraints. I'll speak about the complementarity, the fact that any serious legal complaint has effective machineries in Israel. I was Attorney General. I was on Israeli Supreme Court together 20 years. Before that, I was the Cabinet Secretary for many years and legal advisor of the Foreign and Defense Ministries. We investigate any complaint by Palestinians. They have access to our Supreme Court and what's known as the High Court of Justice procedure. We were not obliged by international law to give Palestinians standing in our national Supreme Court, but because of the special situation, they, meaning individuals or human rights organizations or anybody who wants to file a petition in the Supreme Court, right away the Supreme Court can do it, and every complaint is looked at. So, and everybody in
Mr. Rubinstein, I am just the bad guy that have to tell you that you have 1 minute to conclude.
Okay, so you're the good guy, and I'll be done with in a minute. All I want to say is that Israel investigates, for instance, when there was a massacre of Muslims by Christians in Lebanon in the 80s, Lebanon did not investigate. Israel investigated what was purported to be an indirect responsibility of a certain kind, and it was seriously by investigated when with sanctions. You know, in 1975, when the Zionism's racism decision was accepted in the UN, our former president and Ambassador Herzog, the father of General Mike Herzog, who is one of the organizers of this, tore the decision on the UN floor. I sometimes have the feeling, the urge to do this to many of the of such decisions that we have in the General Assembly and in human rights UN bodies, and at the end of the day, so virtually I'm doing this, but practically, what will this investigation, if it takes place, bring to law enforcement and to peace? Zero. We need peace. We need negotiation. We don't need investigation. We do them themselves when they are needed. Thank you very much.